A woman is on the phone with her ex. He tells her he is going to write a note and kill himself. She hears what sounds like a gun being cocked, then a pop, then nothing. The line goes dead. She calls 911. Police arrive at his home in Montana, knock, shout into an open window, get no answer, and through the glass they can see an empty gun holster and what looks like a suicide note sitting on a table. What happens in the next 60 seconds, whether those officers have the legal right to open that door without a warrant, became a question the Supreme Court had to answer for the entire country, because lower courts across America genuinely disagreed on it. Some said officers needed probable cause, the same high bar used to investigate a crime before they could cross that threshold. Others said a lower standard applied. On January 14, 2026, the Supreme Court settled it, unanimously, all 9 justices agreeing, in a case that started with a single phone call and ended up rewriting the national rule for one of the most common, high-stakes decisions a police officer ever has to make in the field. The answer affects what happens the next time police show up at your own door, or a neighbor's, believing someone inside might be in danger. Whether that call comes from a worried parent, a concerned friend, or an ex-partner who just heard something terrifying on the other end of a phone line. Quick thing before we get into it. I break down Supreme Court rulings that actually affect how police can interact with you in your home, the moment they are decided, not weeks later once the summary has already gotten fuzzy and the exact wording of the standard has been lost somewhere between the opinion and the headline. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into exactly what the court said and what it means practically. The case is called Case versus Montana, and yes, that is genuinely the petitioner's own last name, William Trevor Case. Here are the facts exactly as the record lays them out. Case called his ex-girlfriend and told her he intended to kill himself and was going to write a note. During the call, she heard a sound consistent with a gun being cocked, then what sounded like a shot, and then the line went silent. Believing he had shot himself, she called 911. Montana police officers responded to his home, knocked on the door, and yelled his name into an open window. They got no response. Looking through the window, they saw an empty handgun holster and what appeared to be a suicide note. After repeated attempts to make contact failed, the officers made the decision to enter the home without a warrant to check on him. While clearing the residence, an officer approached a closet in an upstairs bedroom where Case was hiding. Case suddenly threw open the closet curtain while holding what looked like a gun. Fearing he was about to be shot, the officer fired a single shot, hitting Case. Officers later found a handgun in a laundry hamper near where Case had been standing, not directly in his hand at that final moment. Case survived, was taken to the hospital for treatment, and was subsequently charged with assault on a peace officer. He moved to suppress the evidence from the encounter, arguing the officers had violated his Fourth Amendment rights by entering his home without a warrant in the first place, a motion that, if successful, would likely have unraveled the entire criminal case against him. A trial court denied that motion, a jury convicted him, and the Montana Supreme Court upheld the conviction in a divided 4-3 ruling, applying the state's own community caretaker doctrine to justify the entry, with 3 dissenting justices on that court disagreeing about exactly how that state doctrine should have been applied. Case appealed to the United States Supreme Court, and the specific question the justices agreed to resolve was this: does the Fourth Amendment's emergency aid exception, which allows police to enter a home without a warrant to help someone in danger, require officers to have probable cause, the same standard used when investigating a crime, or does a lower standard apply since checking on someone's safety is fundamentally different from gathering evidence? This question had genuinely split courts around the country for years before the Supreme Court agreed to step in. Some federal appeals courts and state Supreme Courts had been requiring something close to probable cause before allowing a warrantless emergency entry, treating it essentially the same as any other exception to the warrant requirement. Others had settled on a standard below probable cause, closer to the reasonable suspicion used for brief investigative stops. Still others used language that sounded similar across cases, but that, on close inspection, meant meaningfully different things in practice, which is exactly the kind of inconsistency that eventually forces the Supreme Court to step in and draw one clear national line, since the alternative is that whether your Fourth Amendment rights protect you during a medical emergency literally depends on which state or federal circuit you happen to live in. Here is exactly what the court held, and it is worth reading closely because the exact wording is what lower courts will be applying in every similar case from now on. Justice Elena Kagan wrote the opinion for a unanimous court, all 9 justices agreeing on the outcome, a level of agreement that is genuinely rare in Fourth Amendment cases, which tend to split along more predictable lines given how often they involve tension between individual privacy and law enforcement authority. The court reaffirmed a standard it first set 20 years earlier in a 2006 case called Brigham City v. Stewart, and again applied in a 2009 case called Michigan v. Fisher. Under that standard, police officers may enter a home without a warrant if they have, in the court's own words, an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. Kagan's opinion explicitly rejected the idea that officers need probable cause in this specific context. Her reasoning is worth understanding in plain terms. Probable cause, she explained, is a concept built for criminal investigations. It measures the likelihood that evidence of a crime will be found somewhere, a backward-looking question about whether a crime probably happened and whether proof of it probably exists in a particular place. Checking on someone's safety is a forward-looking question entirely, whether someone right now, in this moment, needs help, which is not the kind of question the probable cause framework was ever built to answer. Checking on someone's safety is not an investigation into a crime. It is what the court called a non-criminal, non-investigatory situation, and forcing a criminal investigation standard onto a welfare check would, in the court's words, fit awkwardly at best. The opinion used a memorable phrase to describe how firmly it was reaffirming the existing rule, stating that Brigham City's reasonableness standard means just what it says, with no further gloss, meaning lower courts do not get to quietly raise the bar by importing probable cause into it, and importantly, they also do not get to quietly lower it either. 2 justices wrote separately, even though both agreed with the outcome, and their separate writings are worth knowing about because they highlight exactly where future litigation is likely to focus next. Justice Sotomayor wrote to underscore specifically that the Montana Supreme Court's opinion had appeared, in her word, erroneously, to apply a standard lower than objectively reasonable basis, essentially flagging for lower courts everywhere that this ruling is not just about rejecting probable cause, it is equally about rejecting standards that are too permissive in the other direction. Justice Gorsuch also wrote a separate concurrence, joining the court's opinion in full while offering his own additional reasoning tracing the emergency aid exception back through the line of cases that established it. Neither separate writing changes the outcome or the governing rule, but together they signal that at least 2 justices wanted to be especially precise about exactly where the line sits, which is often a sign of where a similar case is likely to get litigated again down the road. That second half of that sentence is exactly where Montana's own courts went wrong, and it is worth understanding both directions of this ruling, not just the half that rejected probable cause. The Montana Supreme Court had upheld the entry into cases' home under its own community caretaker doctrine, a standard requiring officers to have, in that court's words, objective, specific, and articulable facts to suspect someone needs help. The United States Supreme Court pointed out that this phrasing actually tracks a different, lower Fourth Amendment standard entirely, the reasonable suspicion standard used to justify a brief street stop, not the objectively reasonable basis standard that actually governs home entries. So, this ruling is not simply a win for law enforcement across the board. It sets one specific defined standard, sitting above mere reasonable suspicion, but below full probable cause, and any court, in any state, applying either a higher or a lower bar than that is applying the wrong rule after this decision. Now let's talk about how the court applied that standard to the actual facts here, because this is where the ruling becomes genuinely useful for understanding what objectively reasonable actually looks like in practice, rather than as an abstract legal phrase. The court walked through the specific pieces of information the officers had before they ever opened that door. A direct report of a suicide threat from someone who had just been on the phone with him. The sound of what seemed to be a gun being cocked and fired during that same call. The call going completely silent afterward. An empty gun holster visible through the window. What appeared to be a suicide note also visible, and no response at all after repeated attempts at contact. The court said that, taken together, these specific facts supported an objectively reasonable belief that Case was already injured and needed emergency medical help, or was about to be. This detail matters for anyone trying to understand what actually counts under this standard. It is not a vague gut feeling. It is a specific combination of concrete, articulable facts observed directly by the officers at the scene, not just a general concern or an anonymous tip standing alone. Notice also what the court did not require. It did not require the officers to be certain, or even to have the single strongest possible piece of evidence on its own. It required the totality of everything they observed and were told, stacked together, to add up to an objectively reasonable belief, which is a meaningfully different exercise than looking for one decisive fact in isolation. This totality of the circumstances approach shows up throughout Fourth Amendment law generally, not just in emergency aid cases, and understanding it helps explain why courts resist simple checklists for these situations. Two cases with an identical single fact can come out differently depending on everything else surrounding that fact. The case also raised a genuinely difficult argument that the court had to address directly, and it is worth understanding because it comes up in real police encounters more than people realize. Case argued that by entering the home at all, the officers themselves created the confrontation that led to him being shot, sometimes described as a suicide by cop scenario, and that this possibility should have made the entry itself unreasonable. The court did not dismiss this concern as irrelevant. It acknowledged that the risk of provoking an escalation is genuinely one of the factors that goes into the overall totality of the circumstances analysis, a real, recognized cost of choosing to intervene rather than wait. But the court concluded that this single risk, weighed against everything else the officers knew, the direct suicide threat, the sound of a shot, the silence that followed, did not make their decision to enter unreasonable. The court framed the choice the officers actually faced honestly, not as a clean, risk-free decision, but as a genuine judgment call between two dangers: the risk that entering could provoke a confrontation, against the near certainty that not entering could mean leaving a man who may have already shot himself without any medical help at all. In the court's own words, the Fourth Amendment did not require the officers to leave him to his fate. This part of the ruling matters beyond this one case, because it establishes that the possibility an intervention might escalate a situation is not, by itself, a legal veto on that intervention. Courts will weigh it as one factor among several, not treat it as automatically disqualifying. The action step here for understanding your own rights is that officers are allowed to weigh the risk of confrontation against the risk of doing nothing, and courts will generally defer to that judgment call made in the moment, evaluated from the officer's perspective at the time, not with the benefit of hindsight after the fact. Let's talk about what this actually means if you or someone you know is ever on either side of this kind of situation. If police show up at your home because a friend, family member, or neighbor called in a welfare concern, you should understand that officers do not need a warrant, and they do not need probable cause of a crime to enter if they have specific, articulable facts suggesting someone inside is in serious danger. A vague, generic worry alone, with nothing concrete behind it, would not meet this standard, but a specific combination of facts like the ones in this case likely would. If you are the one who might need to call for a welfare check on someone else, understand that the more specific, concrete information you can give the dispatcher, exactly what you heard, exactly what was said, exactly when contact was lost, the stronger the legal basis officers will have to act quickly rather than waiting, and the faster they can move past the threshold question of whether they are even allowed to enter and toward actually helping. If you are ever in a situation where officers are at your own door for a welfare check, understand that de-escalating the moment, responding, showing yourself, communicating that you are safe, is the fastest way to resolve the situation without an entry becoming necessary at all, since the entire legal justification for entry disappears the moment officers have a reasonable basis to believe you are not, in fact, in danger. Let me clear up two things people commonly get wrong about this ruling, because both misunderstandings could lead someone to a false sense of security in exactly the wrong moment. The first misunderstanding is thinking this decision gives police blanket authority to enter any home whenever they claim concern for someone's safety. It does not. The standard still requires specific, articulable facts, not a hunch, not a generic complaint, and not mere access to a home. An officer who cannot point to concrete, observable facts supporting a genuine belief that someone is in danger has not met this bar, and evidence obtained through an entry that fails this test can still be suppressed in court exactly the way case tried. unsuccessfully, to suppress the evidence here. The second misunderstanding is thinking this ruling has anything to do with investigating crimes. It does not. The emergency aid exception exists specifically for non-investigatory, non-criminal situations, checking on someone's physical safety. If officers are actually looking for evidence of a crime and dress that search up as a welfare check without a genuine, articulable safety concern behind it, this ruling does not protect that entry, and courts remain fully capable of seeing through a pretextual claim of emergency aid used to sidestep the ordinary warrant requirement. A third point worth understanding related to both of the above is that this standard is evaluated objectively, meaning a court asks what a reasonable officer would have believed given the specific facts available, not what the individual officer subjectively felt or intended. An officer's private motive, good or bad, does not by itself make an entry lawful or unlawful. What matters is whether the observable facts, viewed objectively, would lead a reasonable officer to believe someone needed help. It is worth placing this ruling in the broader family of cases it belongs to, because this is not an isolated decision. It is the latest chapter in a line of precedent going back 2 decades. Brigham City versus Stewart, decided in 2006, first established the objectively reasonable basis standard. In a case where officers responded to a noise complaint and, looking through a window, saw a juvenile punch an adult hard enough to draw blood during an ongoing fight inside the house, then entered to stop the altercation. Michigan versus Fisher, decided in 2009, reaffirmed the same standard in a very different fact pattern. Officers responding to a disturbance call who saw a damaged pickup truck in the driveway, blood on the vehicle and on clothing inside the house, and a man inside yelling and bleeding from his hand. Circumstances the court found similarly supported an objectively reasonable belief that emergency aid was needed, even though nobody had reported a specific threat of violence or self-harm the way Case's ex-girlfriend had. And in 2021, a separate case called Caniglia versus Strom drew an important boundary around a related but distinct doctrine, the community caretaking exception, which originally developed out of police interactions with stranded or abandoned vehicles, holding that this vehicle-based doctrine does not automatically extend into the home without something more, specifically the kind of genuine emergency the Brigham City line of cases actually requires. Case versus Montana ties these threads together, confirming that the emergency aid exception has its own well-established standard, separate from community caretaking, and that Brigham City's original formulation still governs it without modification, 20 years after it was first written, and despite 2 decades of lower courts occasionally drifting away from it in both directions. There is a real-world example worth knowing about that shows this exact standard already being applied by a lower court just weeks after the Supreme Court's ruling. In a case out of the First Circuit involving a missing minor whose digital activity had been traced to a specific apartment through location data, officers went to the building after a father reported his child missing and feared she was in danger. One tenant refused them entry, but another allowed them into a common area, and officers ultimately made their way into the specific apartment based on the digital evidence pointing to that exact location. A court applied this same emergency aid framework to determine whether officers lawfully entered without a warrant, and found that the combination of a missing minor, a concerned parent's report, and specific, timely digital evidence placing the child at that particular address met the objectively reasonable basis standard. The takeaway from that case reinforces the same lesson from Case versus Montana itself. The emergency has to be concrete and specific, not speculative, but when officers have specific, articulable facts, including things like digital location evidence pointing to genuine, timely danger, the law does not require them to stand outside filling out paperwork while a genuine emergency unfolds inside. It is also worth noting what that court emphasized about scope, that an emergency aid entry is not an open-ended search. It is limited to addressing the specific emergency at hand, in that case locating and confirming the safety of the missing child, not a general search of the premises for anything else once officers are inside. Step back and look at what this ruling actually settles and what it does not. It settles, unanimously, that probable cause is not required for an emergency aid entry, and it settles that a standard lower than objectively reasonable basis, like mere reasonable suspicion, is not enough either. What it does not do is turn every police welfare check into an automatic green light to enter your home. The standard still requires specific, articulable facts pointing to a real serious risk to someone's safety, evaluated case by case, on the actual information officers had in the moment, not on vague suspicion, and not with the benefit of hindsight after something has already gone wrong. That balance, meaningful enough to actually let officers act when someone might be dying behind a closed door, but not so loose that it becomes a blank check to enter any home on a hunch, is precisely what a unanimous 9-justice court decided was worth putting back into clear, uniform language after watching state courts drift in both directions for 2 decades. There is something worth sitting with in how this case actually resolved, beyond the legal rule itself. William Case survived being shot, was convicted of assaulting the officer who shot him, and lost his appeal all the way up to the highest court in the country. A court that unanimously agreed the officers who entered his home that night, at real risk to their own safety, made the right call under the Constitution. Whatever you think about how that specific night unfolded, the legal question the Supreme Court actually answered was narrower and more durable than any one person's story. It was about what officers everywhere are allowed to do the next time a phone call goes silent and a family member is left wondering whether to call for help. A scenario that plays out in this country far more often than any single news story about it ever captures. If this helped you understand a ruling that could genuinely matter in a real emergency, either as the person police are checking on or the person calling for help, hit like so it reaches more people trying to understand their actual rights, and subscribe if you have not, because I break down rulings like this the moment they are decided, not weeks later once the summary has already lost the nuance that actually matters. Tell me in the comments whether you had heard of the objectively reasonable basis standard before this video, because that tells me how much foundational Fourth Amendment context to build into videos like this going forward, and whether the next one should go deeper on Brigham City and Fisher directly or move on to how lower courts are already applying this exact ruling in new fact patterns this year.